What is probate and what common forms of probate are used in Florida? Attorney Anthony Chauncey explains that. Probate is a court-supervised process for identifying and gathering the assets of a deceased person, also referred to as the descendant, and paying the descendant's lawful debts and distributing the descendant's assets to his or her beneficiaries. There are two types of court-supervised probate administrations under Florida law: formal administration and summary administration. Formal administration is the most common form of probate in Florida. If an estate does not qualify for summary administration or one of the other alternatives to probate, it must be formally administered. Even if formal administration is not required, it may still be the best choice of Florida probate proceedings based on the circumstances of the case. In formal administration, there is close court supervision of the collection and distribution of the descendant's assets. The process unfolds in 3 stages: opening the estate, administering the estate, and closing the estate. Summary administration is a shortened form of Florida probate that does not require the appointment of a Florida personal representative. Florida summary administration usually requires less time, effort, and expense than formal administration. There are 2 ways in which an estate can qualify for summary administration in Florida. For summary administration to be available, 1. The descendant must have been dead for more than 2 years, or 2. The value of the entire estate subject to administration in Florida, less the value of property exempt from the claims of creditors, must not exceed $75,000. Even if the estate meets one or both of these requirements, summary administration is unavailable if the descendant had a last will and testament that specifically directs formal probate. Call attorney Anthony Chauncey for a free case evaluation in Florida at 877-315-5107 or visit www.chaunceylaw.com.